This is file number 24261ST, People versus Edwin Otto Smith. Mr. Smith was charged with an incident that occurred on January 17th of 2024 in the city of Three Rivers, leaving the scene of a personal injury accident and driving suspended. The matter was on the jury docket. We had a pretrial. There were a number of other issues. The defendant pled to failing to stop at the scene of a personal injury accident. The matter was set for set for sentencing this morning. Mr. James McEwill was here on behalf of the prosecution at that time. He's not here today. I'm not sure why not. He's being paid handsomely for contract with the prosecutor's office, but he isn't here. No one else is here except the victim witness staff, bless their hearts. Mr. Luke Knopfinger is here with his client, and the complaining witness, Kimberly Van, is also present. She's represented in a separate matter by attorney Timothy Reed, who is also present. This, right from the start, was a difficult case. And it was resolved with this plea. Good morning, Mr. Knopfinger.
Morning.
What would you like me to know?
Just a couple things. I have a couple things to say, and they may appear to be disjointed, Judge. And I speak from my perspective too. And my client wants to address the court. We were aware right from the jump that there was a civil case. The facts, not just alleged, but admitted to at the last hearing occurred in mid-January. Case sort of just picked up as most cases do. Right from the jump, we knew there was a civil case in the background. And so my advice to my client is, well, with the civil case, there can be potential civil liability. We then became aware that that was resolved. So we took the plea agreement as it was.
Buckle up, guys. Today we're going to step inside a courtroom for a case that has tension written all over it. The judge opens the proceedings, laying out the charges against Edwin Smith and introducing the parties. From the start, there's a palpable sense of unease as the defense attorney begins to frame the story, hinting at civil ramifications and past complications. The stage is set, and the drama is just beginning.
Client made an admission to that. A couple things, Judge, that I would ask the court to consider, and I would inquire whether or not the court received the medical records.
I did. I'm not a doctor or a nurse, but I did review them this morning when I first saw them.
Okay. Well, I sort of licked my lips and sort of it in terms of litigating what was or what wasn't. I'm no doctor either, but I have to say it was sort of one of those issues where I sort of want to litigate those medical records. But I will say that what injury was or wasn't sustained, I don't think is as important as maybe I thought it was. Sometimes I just want to litigate issues. I'll be honest. It's clear to me that Miss Van suffered some pretty significant injuries, and having spoken to her attorney, it's turned her life upside down. She lost her job, and I think it's changed her life. With that too, it also has affected Mr. Smith. He didn't want this to happen. He made several terrible mistakes that night. And so he didn't want this to happen either. He did enter a guilty plea. He did not enter a no contest plea. And I think that's something I'd ask the court to consider. I do want to ask the court to consider how it has affected my client, and I don't want to discount how it has affected Miss Van either. Happy there was a settlement, happy that was resolved, and I'm happy that this case has come to resolution.
From the defense's perspective, the attorney carefully explains why the plea was accepted emphasizing his client's remorse and the existence of a resolved civil case. He paints a picture of a man who made serious mistakes, but who did not intend harm. The courtroom listens as the attorney underscores the impact on both the victim and the defendant, creating a delicate balance between accountability and compassion.
Two. So I'd ask the court to consider all of that, and then my client does wish to address the court. Thank you.
All right, Mr. Smith, what would you like to tell me?
I'd just like to apologize to Miss Van for the whole deal. Truly sorry it
Just a
never
minute.
happened.
Just a minute. I heard a big fuck you. So if you would like to either stay back here or go outside, I can accommodate that. I expect you to be respectful in here. And if I hear it again, you're going to be found in contempt and you're going to go into custody. Do you understand? Do you understand?
Yeah.
All right. We're not sitting around the kitchen table. We're at a court proceeding. And I know you were struck by a car and you have very strong feelings about it. But I don't want you disrespecting me. I'm in here trying to do the best job I can. Go ahead.
I would just like to apologize for all of it. Truly never meant for it to happen. Sorry for any grief I've caused her family or her.
Miss Van, if you think you can keep it together, do you want to speak to me? Please come forward. You can have a seat right here. You might be more comfortable.
Sorry for cussing, but I do not believe in his apology.
Say that again.
I don't believe in his apology.
Well, I guess you don't have to, but he did state it.
The defendant steps forward, visibly nervous, and delivers a heartfelt apology to the victim. The judge navigates tense moments of courtroom decorum, addressing outbursts and reminding everyone of proper behavior. Smith's words are earnest, but the atmosphere remains charged. Every apology and response is scrutinized, making this a suspenseful moment as the court tries to maintain order.
We got a Led Zeppelin fan and a police fan here. Rock and roll morning. What would you like me to know?
I have a statement, but I'm also requesting things. I'm not saying that they can be possible, but I'm also requesting some things to be done.
All right, well, let me hear your statement and what you want me to know.
Hi, my name is Kimberly Van. I was a pedestrian versus car. I sustained 2 fractured bones below the right knee, a ripped soleus muscle. My C5, C6 disc was collapsed and had to be fused. And I had a herniated disc in my lower back and the never-ending fear of getting hit. So when Edwin stated that I walked into his car, it was far from the truth. Edwin has trouble telling the truth. I believe from his past record and his present record, he refuses to obey the law. He still continues to drink alcohol and drive on a suspended license. He cares about no one but himself. He hit me with his car and left me. He talked his girlfriend into filing a false police report so he wouldn't go to jail. I am asking the court to hold him at the max jail time that is possible for this. I'm also asking for probation time and alcohol monitoring if allowed. I also believe this shouldn't be offered work release. He should go to jail and lose everything like I have, my job and all.
Well, I'll let you finish and then I've got some questions.
When Edwin hit me, I was a sole income from my home. I have 4 children and a disabled husband. I have now been fired from American Axle because I was unable to return to work after surgery. I have lost my medical insurance and this is still affecting me to this day. I still have pain in my knees and my legs and my neck.
The victim, Kimberly Van, delivers a powerful impact statement, recounting severe injuries, ongoing pain, and personal loss. She describes fractured bones, a fused spine, and how the accident destroyed her career and family stability. Her demands for the maximum sentence and strict monitoring of the defendant sent a shockwave through the room, highlighting the human cost of the incident.
Please do not be lenient when you go to sentence him today.
Now, the first I was aware that you had lost your job was when Mr. Knopfsinger said it. I was not aware that you'd lost your job at American Axle. Tell me about that.
So they wanted me to return to work back July 25th. And I was unable to return to work because I had to have my neck fused. So I was fired August 17th.
All right, I wasn't aware of that. Now, I'm no doctor. All right, well, what else did you want included?
What do you mean?
You said there were some other things you would request that.
I'm requesting that if there is possible for probation time after jail, I'm requesting that. I'm requesting alcohol monitoring if it's allowed. I'm requesting that he doesn't have work release. He shouldn't have these extra things that I wasn't allowed to have.
I can't do both. I can't give him the maximum jail sentence and probation. There's nothing else I can do to him after that.
I'm
The
so
judge
confused.
begins clarifying the scope of possible sentencing, weighing jail time, probation, and work release options. Van presses her requests, seeking justice and accountability. The courtroom tension escalates as the legal limitations collide with emotional expectations. Observers can feel the intensity as the court navigates the gap between law and personal desire for retribution.
After that.
I'm so confused because I talked to the prosecutor and yet today we don't have a prosecutor to stand here with me with what he has said at the last trial.
Well,
Because he's the one that brought up that he could possibly get probation after jail time and we could possibly ask for alcohol monitoring because this is how the situation came.
all right. Stop. You'll be in the same boat. All right. Let's back up. This was authorized by Chief Assistant Prosecutor Joshua Bayer. He charged as leaving the scene of a personal injury accident and driving suspended. I have a long-standing frustration in personal injury accident cases where I don't know if they have all the information they need at the time of the charging. It is a felony to leave the scene of a serious injury accident when you have a suspended driver's license. Punishable by up to 5 years imprisonment. So he was charged with that. But he doesn't have a suspended driver's license.
It was revoked. He's got a revoked.
He has no license.
It was taken away because two DUIs and hitting a structure before me.
Well, you're aware of that. I'm aware because I was here in 1997 and 1997 and 1999. Two drunk driving, another charge, fleeing and looting. But they were almost 30 years ago. So his driving record doesn't even show it. His driving record shows he has no license. It does not show that he's suspended or revoked. And so he was charged as that. I looked carefully at his driver's license. There's nothing on it. That stuff is so old it doesn't show up on his driver's license. So what SOS shows he has no license, which is different than suspended or revoked. All right. There's also an offense for leaving the scene of a serious injury accident, which is also a 5-year felony. And I guess no one bothered to find out what the extent of your injuries were. I've had six, seven cases like this. I I don't know where the blame lies. I think sometimes prosecutors don't know what they don't know. I don't have what he had back on February 7th, whenever this was authorized. But I believe what you have is a serious injury. So I want to shout this.
In my neck for the rest of my
Yeah,
life.
well, it certainly qualifies. Driving suspended with a personal injury accident. Serious personal injury accident is a felony. Thousands of people driving around with a suspended driver's license. He arguably, his defense is it wasn't suspended. It was just not existent. But
Either way, he didn't have a driver's license behind the wheel.
I don't disagree at all. So then he left the scene. A serious personal injury is a loss of limb or loss of a foot. Loss of limb or loss of use of hand, loss of eye, ear.
I've lost
Substantial impairment of a bodily. You certainly have that.
I've lost motion in my neck because my neck had to be
So
fused.
this certainly qualifies.
She ran into the building.
Stop. So this qualifies. Under what standard you have enough medical evidence to substantial impairment of a bodily function. But do you believe he ran over you on purpose?
I believe he ran.
Now the judge delves into the legal intricacies, examining charges, the defendant's driving record, and severity of injuries. Debate arises over whether the incident was intentional or accidental. As evidence and testimonies are dissected, the courtroom is thick with anticipation, each word from the bench heightening the suspense surrounding possible outcomes.
I believe he ran over me on purpose because he was drinking.
There's absolutely no evidence.
He tested positive for alcohol still 3.5 hours after the accident when he flew in a breathalyzer test.
No, where at?
You can call Officer Fuller done a breathalyzer test and they finally decided to quit hiding from the sheriffs.
What do you know about that? I was not aware of any blood alcohol.
This isn't beyond.
He blew a 0.03 is what he blew 3.5 hours later after hitting me.
How do you know that?
Officer Fuller? He was the investigating officer on the case. He said he couldn't prove that he was drinking and driving because he wasn't able to see him at the scene of the accident, but he was still testing positive for alcohol. He admitted it.
So let me back up a little bit. So you believe he hit you on purpose?
Because he was drinking, yes.
So he said, I don't run over this lady.
I don't think he said, hey, I'm mad at Kim, let's run her over. But I believe he intentionally hit me because he decided to drink that day.
All right, there's a legal distinction. I don't believe he hit you on purpose. I believe this is an accident.
And that wasn't that day.
All right, well, there's no evidence other than what she said. That's
It's in the police record.
It's not in what I have. Looking book sheet, but I don't get a book that day. And certainly the prosecutor have access to it. The disadvantage, they don't have any input from the prosecutor. Either the one that authorized it, or the one that took the plea, or the one that was elected to office. But anyway, I do not believe he intentionally ran over the parking lot. I believe he knew he wasn't supposed to be driving because he hasn't had a license for 30 years, and he panicked and took off. And then there was a rigmarole before they caught up with him. If he was drinking, there certainly isn't enough evidence to charge him driving. So he did not intentionally hit you. This falls under the category of a moving violation causing death. It's the same kind of case. Fortunately, you didn't die. You're here and you have debilitating injuries. And there was a civil case, which there often is. And there was some sort of settlement. I don't need to know what it was. But there's criminal liability and civil liability. The civil case was settled. I don't know if American Axle was a party of it, just your and his insurance. I don't know. But I've said this multiple times. I've been on the bench now for about 22 years, and every two years, when new judges are elected, partner judge and I teach new judge school. And the topic we teach is district court sentencing. I think I've done it six times, seven times, 12 or 14 years. So every two years, I have a new batch of newly elected judges, and I spend a day and we teach sentencing. Now some of it's easy. Driving suspended, driving, shoplifting. The hardest cases a district judge does are vehicular accident homicide cases. Bar none. Now my partner is from Farmington Hills. He's never had one. I have about six a year. I have a terrible case right now where a young woman was driving down US 12. And she's been charged with killing two people. She has no criminal record whatsoever. Been in trouble. She allegedly had a traffic either driving too fast center line. And she killed two people. I had a situation with a young boy who was a student here in Centerville, and he hit a man and killed him. They were out doing solicitations for a newspaper, FFA, going to farm supply stores and other things. No alcohol, speeding, no nothing. Just made a mistake and hit this man and killed him. His wife sat where you are. She was Romanian. She didn't have great English. Her husband died. She lost everything. She lost her sole provider. She lost the person that paid all the bills. She lost that did everything around the house. Talk about turning her life upside down. As opposed to this high school senior who crossed the center line and killed her. I could tell you about more stories like that. Anyway, they're very hard. What's the answer? What do you do? I had a young girl was talking on the telephone. Blew a red light. Was crossing the street. There is no exact right answer. You want him to go to jail for the maximum amount of time. You want him to lose his job. You want him to be on probation and alcohol monitoring. And none of that is gonna fix your injuries. He had an accident, and then he panicked and left. The prosecutor under two different theories, I suppose, could have charged this as a felony. They chose not to. They know more about it than I do. So it's not a felony. It's a misdemeanor. And the way it's charged, it is a district court misdemeanor.
The judge contextualizes a case with broader precedent, sharing his experience with vehicular accident cases and highlighting past tragedies. Comparison to other severe incidents create a sobering perspective. Listeners gain insight into how judges weigh human suffering against legal frameworks, while the gravity of the present case looms, intensifying suspense as the courtroom awaits a decisive ruling.
District court misdemeanor. There is another misdemeanor. accident, traffic violation with serious personal injury. So they never explored the extent of your injury, which was serious. Now, he contends you ran back into the shop, and maybe you did. And
I
then,
had help by.
all right, well, nonetheless, sometimes it takes a minute. Your body's full of adrenaline. You're in shock, but I don't dispute the fact that you're debilitated. I am sorry that you lost your job. It doesn't seem as straightforward as that. If your doctor says, were you cleared by your doctor to go back to work?
No, I had a work note stating that I was supposed to be off work because I had surgery. I wasn't supposed to return to work until the 29th of this month.
Well, didn't, all right, so is the union fighting that with the?
No, the union's not helping me at all.
But there is a action against
There's an action against American Axle.
for wrongful discharge.
Correct.
Okay, so that's not completely a closed issue.
No, this is an ongoing issue.
All right.
But I wouldn't have my job if I wouldn't have gotten hit by a car. And I was the sole income of my family.
I accept that. Similar to the lady that lost her husband. So as far as I can tell, Mr. Smith hasn't been in trouble in about 25 years. I was prosecutor in 1997, 1999. I became judge in 2003. And I haven't seen him once since I came to the bench. So he has a job at American Axle. He has a family. He has expenses. And he did a dumb thing. A serious consequence. The prosecutor makes the charge. The judge makes the sentence. This charge is a misdemeanor, punishable by 3 days in jail. Now, one of the reasons for the leaving the scene crime is I've seen this. People are in an accident. They leave the scene and they leave the person there on the side of the road.
He left me. He decided to say a comment before he left.
All right, we'll hear about that in a minute. But he left you there in a place where there were other people around. So he didn't leave you laying in a ditch bleeding. He knew there was going to be some response. And at that point, he didn't know the extent of your injuries. He knew that his version is you ran into his car. His version is
So after coming off the hood of his car, I walked into it.
Yeah.
You never even knocked the dust.
All right. Stop. All right. So you wanted to tell me something else.
Just go ahead.
Well, you were going to say one more thing. All right. Nothing I say here is gonna make you satisfied.
No,
nothing I say here is
satisfied at all.
Say that again.
I don't expect you to make me satisfied at all. A year in jail is pretty much a slap on the hand. But for him to sit in here, and this is a game for him. It's a joke. Yeah, really. No, ma'am.
Stop. You're not helping things at all. And neither are you. I can't make you happy, and I can't make you remorseful. Other than what you said here, your version is that I don't know. I wasn't there. Usually they'd have some video. I don't believe there's any video of this. Would have been helpful. For all some video in the parking lot to show exactly what happened.
HR done their investigation and he admitted to he admitted to HR that I was on the hood of his car.
Because there is video, the accident is out of frame.
Yes, that's what I understood.
So, yes, so
We didn't actually see what happened. Yes.
The victim and defendant exchange tense moments, with Van expressing frustration and anger over her personal and professional losses. The judge intervenes repeatedly, balancing empathy and authority. Every statement fuels emotional stakes, and the courtroom becomes a stage for raw, unfiltered confrontation. Observers witness the struggle between justice, accountability, and human emotion.
no.
Yes. All right. There is no right answer to this. In fact, I'm going to use this as a fact scenario at our next judicial training in January. I am going to do a 12-month probation. And he isn't going to use any alcohol or any controlled
So he's not even going to jail for this?
Stop.
I'm just asking.
I'm doing the sentencing. Stop. He's not in charge of this. I am. And no matter what I say, you're not going to be satisfied with it. So
I'd like him to go to jail.
Yes, I certainly understand that. In fact, you're so angry that you undermine your effectiveness. Because nothing that would be done here would satisfy you. So you're so angry. You've been angry at everybody. You've been angry at prosecutors. You've been angry at me. You've been angry at victim advocate. I'm not very happy about that either. But I saw some exchanges between you and the prosecutor. You're so angry that you're unreasonable and undermines your effectiveness. I'll just leave it at that. No alcohol. Test as directed police officer, probation officer. No drugs, including marijuana. I don't know if you use marijuana. It's eligible for recreational use, but you can't use that. No driving. You don't have a driver's license. You'll have a very difficult time getting your license, particularly after this. You might as well accept that you'll probably never have a driver's license. Those two old driving offenses. The driver license appeal division, secretary of state have an even longer memory than I do. And so you would have to them that you're eligible to get a license back with a restriction. So you may have been able to do that, but you throw this scene into the mix. You're just out of chances. The fine is zero for a court fine. I'm going to order 10 days jail to be served weekends or work. I'm not going to make you lose your job. $75 victims' rights fee, $50 minimum fee. $150 attorney fee. I think you told me that. Thank you. And a $480 probation oversight fee.
The moment of truth arrives as the judge announces the sentence. Probation, limited jail options, fees, and restrictions. The tension in the room is palpable as the parties absorb the decision. This is the climax of the legal drama, where law and consequence intersect, leaving everyone in suspense about whether the ruling satisfies either the victim or the defendant.
Go get her. Please come up and have a seat.
Whatever you want.
All right. You want to say a little more? Is there anything else you have to say? All right. You should just go now. You're good to go. All right. Come here. I find that you're in contempt and you're going to jail 24 hours. Right now, yes. Really. Officer, I'd please ask you to take her into the back. Don't look at Mr. Reed. You did this to yourself. You're going to jail 24 hours for continuing disrespect. I am sorry about everything that happened in this accident. But I gave you a chance to just leave and then she can go to jail right now. I went out of my way to do this, and you don't have to like be respectful. You went out of your way to be not respectful. She can go to jail right now. 24 hours. Found to be in your
Can you get
Take her out of here.
You ain't gonna get it.
You're not following her. You're not following her.
She has a driver's license.
Yes.
One civil liability they have.
Chaos returns as a victim is found in contempt for disruptive behavior and immediately sentenced to 24 hours in jail. The courtroom erupts with tension as decorum is enforced in real time. This sudden escalation highlights the fragile balance of authority, illustrating how high emotions in court can lead to swift, dramatic action. Observers see firsthand the cost of losing control.
All right, I'm sorry. I want you to report down to the probation department. I took it as far as I could take it. You've got 10 days to do. You can choose to do it all at once or do it on weekends or even work release, but I think weekends are the most effective. No driving. If you can complete this within 6 months, you could be discharged early. Ross, you may want to go help him. We need to get her out there where she can be properly cared for. All right. That concludes the record on this matter. I'll give you this referral down to the
It's not funny, Luke.
No, it's not funny at all. I take no joy in this. All right, just everybody calm down and go on about your business. It's not at all. A special record regarding contempt finding just made regarding plain witness in the last case. Mr. Timothy Reed is here. He represents that contempt defendant in a civil matter, which we discussed in the matter of the sentencing in the last case. And that was in the sentence of Edwin Smith. The defendant was quite animated, warned her at the beginning of the proceedings for cursing in the courtroom, like said. She had two other bursts, both on the way out of the courtroom. I brought her back in, and she said, "Okay, I'm good." And I said, "You should just go." Then she gave me one more. This is bullshit on the way out the door. So I found her in contempt and gave her 24 hours jail. We just had a session on contempt at the district judge's conference in August. Very good one. I believe I'm within my parameters to find contempt in this proceeding. But Mr. Reed has indicated he's going to file an emergency stay of my contempt ruling and ask for the Chief Judge Pattison to rule on this. And so transcripts and have another judge to review these videos. So I'm willing to allow that. I certainly not oblivious to the fact that you have a serious injury as a result of this, and there's been a lot of consequence to you. But you're using your victim as a weapon, and. one of the people you were wielding your weapon on was me. You don't have to like my ruling, but you can share your opinion later in my presence. You swear all you want when you get home. To me, you can't do it to me. So anyway, I'm going to stay in my contempt finding. Mr. Reed is going to.
The judge provides detailed reasoning for contempt ruling, explaining legal rights and the potential for appeal. The courtroom settles into a reflective state as procedural clarity tempers the earlier chaos. Observers are left analyzing how courtroom authority, victim impact, and procedural law intersect, providing a unique glimpse into judicial decision-making under pressure.
I'll file an official appearance, Your Honor, request for hearing.
It needs a caption, so it'll be contempt in the matter of Edwin Otto Smith.
Utilize that SD number as the case number?
Yes.
Okay, that will be fine.
All right, so, you're free to go.
I'll explain exactly what's going on. Thank you, Your Honor. I'll have that filed today.
All right.
I've got, give it a second. Okay, well, I'll get it out in the hall, so I'll meet them out there, they will go in office and meet. Hold on one second, it's gonna get the band off back there. So. I'm glad I wasn't sure how to have, because that is one of those, but that makes sense. I think for records purposes, we'll be able to track it. And the record is all in the context of. So when I request the transcript, that case number today.
Yes,
Thank you, Your Honor. Yeah, I'm gonna call in and talk about that.
All right.
Is that it for your morning?
Yeah, that's, we ended with a bang, or a thud. Yes, that's it for my morning.
When I referee, that was hardest part, maintaining order and knowing that, of course people were upset, but I always really struggled with that.
I don't do it a lot. In fact, we just had a session and they said, take a breath, count to 100. So I let her first time, and then she bullshitted me on the way out, and I came back in to not find her in contempt, and then she did it, again.
I'll expect my CJ from TJ's.
Boy. Two things I said are correct. She is not going to be satisfied, and she uses her victim as a weapon.
My conversation, not swinger about, consults on that. I know it's been.
And I don't. They could have charged it as a felony. They didn't. And it's like she didn't do anything. To endear herself to them. She was fuck you with Dave Marvin, and the bailiffs, victim witness staff, and Mr. Marvin wasn't going to go out of his way. Although it would have been helpful. Prosecutor's office had shown up.
No, that's recurring.
Yes, but according to TJ, they're paying $3,000 to be a special prosecutor. Seems like he could have come in for this. Anyway, thank you, Ross.
Victims of juveniles like larceny. They would just want hands cut off. That victim impact opening.
Well, I am going to use this as an example for judge sentencing.
Where you have a victim that wants execution, nothing else was satisfied.
It did surprise me that it had alcohol in it, because I didn't see that anywhere. And I'm not saying she wasn't being truthful, but I guess I better make some notes in that case.
Finally, the case wraps up as the judge reflects on lessons learned, logistics or follow-up, and the broader implications of victim impact and judicial management. Tension dissipates, leaving a courtroom marked by emotional and legal complexity.